Good afternoon, and welcome to another episode of Condo Insider. And my name is Jane Sugimura, and I'm going to be your host today, and the presenter, because we don't have a guest speaker today. Today we were going to talk about legislative updates, mainly because even though we had a very short legislative session, then they went into recess right away because of the pandemic. The governor sent out his veto list this past Monday. So we kind of know what's going to pass and what's not going to pass. But before we get to the legislative updates, what I want to do is talk about something that affects a whole lot of condo owners. And, most people, most condos have like a 50% owner occupancy ratio. And that means that the other 50% are investor owners and they're landlords and they're renting out their units. Okay, so this is for those people out there who are investor owners of condominiums, because 2 days ago on September 1, the Centers of Control of Disease Control, which is the CDC, issued an order, and this is a federal agency. They issued an order calling a halt to evictions because the fact that there may be evictions, it causes people to move in with other people and it increases homeless situations. In other words, evictions contribute to the spread of COVID-19. And so the reason why the CDC, you might say, well, why is the CDC getting involved in this? They're the ones who are, telling you what to do about COVID-19 or telling the states what to do about it. But President Trump, I think 10 days ago, signed an executive order because Congress could not get their act together and come up with an extension of benefits that ran out, at the end of August, because there was some congressional legislation that allowed funds to go to the city, to the counties, and to the states to help with relief. And, some of this relief was in the form of rental assistance and, to renters so that they wouldn't lose their homes. And, the reason I'm talking about this today is because, there's, so many people who rent units in condominiums, and these conditions, there are civil penalties for noncompliance by landlords. And I'll get to the civil penalties. Okay, this order is just a temporary halt to residential evictions. It doesn't affect non-residential evictions. And what this order does is it doesn't excuse tenants from paying the rent or any other monies that, have to be paid to the landlord. What it does is it just says that if you are a landlord, you have residential property and your tenant's not paying you rent, you cannot evict them. And this order goes into effect, or went into effect, September 1, which is 2 days ago, and it's going to remain in effect until December 31, 2020, and it may be extended. But anyway, and with tenants, if the tenant, you can still do evictions, but you can't evict a tenant for non-payment of rent. You can evict a tenant if they're acting badly, or let's say they're violating the business rules and the building rules and regulations, or they're doing criminal conduct. They're selling drugs, or they're getting into fights, or they're acting in a way that affects the health and safety of other people in the building. If you're not suing for rent, then you can still do evictions in residential properties. Okay, if the tenant wants to take advantage of this order, this CDC order, they have to file this affidavit, or they have to do a declaration signed under penalty of perjury. And this CDC order is all over the internet, and it was in the newspapers 2 days ago. So they can go and, download the form of petition, declaration. And this is what they have to say. They have to say that they don't, if you're a single person, that you don't earn $99,000 in 2020, or if you're a married couple filing jointly, your threshold is 199,000. So that means almost anybody would be eligible. Also, you have to state that you have used best efforts to obtain government assistance for rent and housing. And I'm going to come back to that one. And that they are not able to pay rent due to a COVID-19 event. That means that you can't pay rent because you lost your job, or your business, the place where you work shut down, or your hours were cut. You have to show that your inability to pay rent was due to a COVID-19 event. You also have to show that you are using your best efforts to make timely partial payments to the landlord. And finally, you have to say that if you're evicted, you're going to become homeless. And you have to sign this petition under penalty of perjury. And, one of the conditions is that you need to show good faith efforts that you have applied for government assistance. What's on the screen now is a flyer. And this flyer talks about the city program. The federal government, Congress, through the federal government through Congress, passed laws that gave money to the state of Hawaii and to the city and county of Honolulu and to Maui and to the Big Island and to Kauai. Okay, and the funds that were given were part of the CARES Fund, and that was something that was passed by Congress. And all of these, and for Oahu, there was 25 million, and those monies can be used for rent, for utilities, for childcare, elder care. You have to apply, and that's the flyer that's on the screen right now. And if you want to get more information, you can go to Aloha United Way, and they will have the applications, and you can apply for and they have some conditions. You have to have, I think, less than $10,000 worth of liquid assets or any kind of assets, and you have to have lost your job, or you have due to a COVID-19 event. And the state bill, and that's getting rolled out right now. And but the governor signed the bill about a week ago. And so the information about that program should be coming out. Aloha United Way is also contracted to oversee that program for the state. But what we heard is that Aloha United Way is subcontracting with the community health centers like Waianae Community Health and Waimanalo Community Health, and some credit unions. And the list of the entities that will accept the applications is also on the website. So if you want to do the state program, go on to the Aloha United Way. And in both the state program and the city program, the rental assistance is $2,000 a month. And if you qualify, the payments are made directly to your landlord. They don't come to you as a tenant, but you need to apply, and then the payments will go to your landlord. And if you're on the neighbor islands under the state program is being run by Catholic Charities. And I don't know how that's going to be administered, but you should go on the website. If you're on the neighbor islands, go on the Catholic Charities website to find out how they're going to be administering that program. And it's $2,000 per month. On Oahu, it's $1,500 per month on the neighbor islands. And so as part of this CDC order, you need to show that you have applied for one of these programs or some other government program. Otherwise, you're not going to be exempt from evictions. And the reason why I'm telling you this is because there are huge, very substantial penalties if you violate the order. And this is a federal order, so it kind of trumps state law. Okay, so criminal penalties. Let me tell you what the criminal penalties are. It's no more than $100,000 if the violation does not result in death or 1 year in jail. Okay, criminal penalties. That means that the U.S. attorney is going to be coming after you, and you will be in a criminal court in the U.S. Federal District Court. And if you are, and that's if for an individual landlord. But if you are running your rental unit as a corporation or an LLC or something that's not an individual, then the penalty is $250,000 if the violation results in death or 1 year in jail. Oh, I'm sorry. Strike that. It's $100,000 if the violation does not result in death or 1 year in jail, or $250,000 if the violation results in death and 1 year in jail. If you are not an individual, but you're renting your unit out as a corporation or an LLC or a partnership, then the fine is $200,000 per event if the violation results in death, and no more than $500,000 per event if the violation results in death. Okay, so those are pretty substantial penalties, and so you don't want to mess around. And so if you have any questions, you need to consult a lawyer. Before you decide you're going to evict the tenant. You need to be, very careful about what you do, and you have to be prepared for your tenants coming to you with these declarations, saying that, they're giving you this declaration because of the federal CDC order. And if you get one of these declarations, that means that you can't evict them. And you need to be prepared. You need to know about this. You don't have to have, and I suggested if you have any questions, you go online. You can probably find it if you Google it. And it is the CDC order halting residential evictions. And you should be able to find it. There's no number because the article that appeared in the news on September 1 didn't have a number. It had not yet been published in the federal record, which is the way most of these orders, get circulated. So we don't have a number yet for it, but it's on the internet. It's in the Star Bulletin, and you need to know about this before you decide to evict your tenant, because if you screw up, there are huge penalties, or you could possibly go to jail, which is seems very draconian. But anyway, you don't want to mess around with this. So this is just FYI, and I'm bringing it to your attention because we just found out about it 2 days ago. And so right now, what I'm going to do is we're going to take our break, and then we're going to come back, and I'm going to talk to you about what the Hawaii Legislature did to pass laws that affect condominium and condominium living. Okay, thank you. We'll take our break now.
Aloha. My name is Mark Shklov. I am the host of ThinkTech Hawaii's Law Across the Sea program. Being a lawyer has many aspects, and I try to cover them every time I do a program of Law Across the Sea. Not everything has to do with law or being a lawyer per se. Some of it has to do with the people you meet, the things you see, the places you visit. And that's what I try to combine in ThinkTech Hawaii's Law Across the Sea. Thank you for watching. Aloha.
Okay, thank you for coming back. This is another episode of Condo Insider, and my name is Jane Sugimura. And today, the name of the program is Legislative Update. And the Hawaii Legislature, had a very unusual session this year. Because of the COVID-19 pandemic, they took a recess in March when the governor's emergency orders were issued. And then they came back in April for a short portion of the session to finish. And so, because, a lot of the time of our legislators were understandably taken up with issues relating to the unemployment and, to the economic shutdown and the rise of, the COVID cases and how to control them. Understandably, a lot of the bills that were pending just never made it out of the session. But 3 bills did make it out. 3 bills, did make it out of the legislative session and were referred to the governor by the end of the legislature, which is called sine die. And as part of this process, the legislature, submits the bills to the governor, and the governor then has 45 days to issue what is called his veto list. And the veto list came out this past Monday. And none of these 3 bills that were still alive that were sent to him, at the end of, I think it was at the end of July, were not on that veto list. So that means that by September 10th, he should be signing these bills into law, or if he does not sign them, they will become law as a matter of law. They automatically become law. And so I'm going to tell you about what these laws are about. The first one is Senate Bill 2871, and that one has been signed by the governor. And that one now is Act 12. It was signed on August 12th. And what that one does, and it applies to a bunch of state agencies, but as it affects condominiums, it allows the Real Estate Commission, which is in the State of Hawaii Department of Commerce and Consumer Affairs, the DCCA, it allows the Real Estate Commission to adjust the collection of annual fees collected from condominium associations to maintain a reasonable relationship between the fees generated and the costs of service rendered by the Condominium Education Fund. And for people who don't know this, over 30 years ago, the legislature decided, because there was, there was this crisis at the time, where there was a lawsuit and the board of directors of the particular association were getting sued. And because, people sat on boards, they're volunteers, and they got scared. They were resigning en masse, and nobody wanted to be a board of director. And that's when the state of Hawaii decided, okay, what we're going to do is we're going to set up an education program. It's called the Condominium Education, and we're going to set up a fund. It's called the Condominium Education Fund. And we're going to allow the Real Estate Commission to collect money from all of these associations. And back in the day when this thing whole started, it was about 30 years ago, the fee was $1.25 per unit for the building. So if you have 100 units, times $1.25, that would be what, $1,000, $1,025. Anyway, as of last year, when I checked with the DCCA, the costs that they were charging, the condominium fee was $10 per unit. So for my building, which has 300 units, $10 per unit would be $3,000, right? $3,000, and it's biannual, so it's every other year. And our association would have to write a check to the state of Hawaii, and it went to the Real Estate Commission. And so that's one building. So you can see with all the thousands of condominium associations in the state of Hawaii, that can result in a lot of money. And in fact, that's why the legislature decided that, they were going to not allow the fees to be collected every year, because after a while you get like millions of dollars, and the agency just can't spend that much money. And so they end up with this huge amount of money sitting in these accounts. And so that's why this bill was passed, which says that in other words, if you don't spend it, you can't collect it. And so it allows the agency, in this case, the Real Estate Commission, to look at what they're spending and make an adjustment. So if they have too much money, the next biennial, they won't be able to collect money from the association. And this is a good thing. This is a good thing. Because we don't want because if you're a condominium unit owner, the condo ed fund comes out of your maintenance fees, and so that means that if you were living in my building, $10 per biennium, which is $5 a year of your maintenance fees, is being paid to the state of Hawaii to the condo ed fund. And you ask, well, what do they use that for? Well, they use it for dispute resolution and for education of board members and condominium unit owners. And there are groups that, give educational programs, and they are subsidized by this fund. And the DCCA, in fact, has their own programs, which those funds are used to subsidize. And so if you have any questions, what you need to do is you can email the Real Estate Commission or go onto their website. Go to the DCCA and just Google Hawaii Real Estate Commission, and you'll go to their website. And there's a lot of material on their website. There's a lot of stuff that they do, and it's there for use by condominium associations and their unit owners. And so you should take advantage of it because you're paying for it. Okay, so why don't we go on to the next bill? The next bill is Senate Bill 2421, and the governor has not yet passed this one. Okay, and what it does, there's something called a sunset provision. And when bills are passed, if the legislature is really not sure whether or not they want it to be permanent, they put a sunset provision in there. And the sunset provision says that, okay, let's try out this new law, and instead of having to go to the trouble of repealing it later on, we'll just say that it automatically expires on such and such a date. And so this one had one of those sunset provisions, and it would have expired in June of this year. And so because the law was working fine, there were a lot of us who wanted it, the sunset provision removed. So that is what happened in this case. And so so what happened with Senate Bill 2421 was it removed the sunset provisions from Act number 195. So that means that the stuff in 195 is now permanent, doesn't have the sunset provision that automatically repeals the law. And so what became permanent? There was something called priority of payments policy, and it allowed associations to take a unit owner's monthly payment and apply it in certain ways. Maybe if you were late before, they would apply it to the late fees, the fines, and the legal charges first, and then you would always end up delinquent and incur more late charges. And this created a whole bunch of problems. Anyway, the priority payments policy is now gone. That's permanent. Another thing that 195 does is it clarifies procedures on how payment plans affect ongoing non-judicial foreclosures. And this is really complicated. And but so this bill clarified that certain things had to happen if the unit owner did a payment plan with the association to dealing with non-judicial foreclosures. And so those provisions are now permanent. It also clarifies the rule used to be that if you had a dispute with the association, you had to pay first and dispute later. This clarifies that it only applies to common expenses. It doesn't apply to late fees, attorney's fees, or fines. In other words, you don't have to pay them first and to dispute them. You can pay your maintenance fees, your common assessments, and then dispute your fees, late charges, and penalties. And the second bill, which is almost the same thing, had a sunset provision. It's Senate Bill 2425. And that bill removed the sunset provision from Act 196, which is now permanent. Okay. And so the things that are permanent is that 196, what it did was expanded the scope of the condo ed fund that we talked about, that the Real Estate Commission administers, because the condo ed fund is used to subsidize these mediations and arbitrations. So anyway, 196 expands the scope of condo ed fund to subsidize the cost of voluntary binding arbitration between parties. That means if you go to arbitration, the condo ed fund will pay the expenses of that arbitration. Never did that before. And another thing that 196 does, it expands the scope of parties who are entitled to mediation of disputes under the condominium statute. And this also applies to evaluative mediation, which is covered by the subsidy from the condo ed fund, which means that if you do evaluative mediation to resolve your disputes that you have, that the state of Hawaii will pay for it out of this condo ed fund. And this bill also expanded the types of people who could take advantage of mediation. It used to be only the owners and the boards, and now it's the owners and the boards and the managing agents and board members against other board members. And so that's a good thing. So anyway, those two bills have passed. And the one good thing for those people who have been following the legislation, there was a bill for cooking oil that would have required associations to set up some kind of a receptacle to collect the cooking oil that people collect. And I don't know if people collect it, but anyway, if rather than pour it down the sink, that people who live in condominiums would have to go down to the basement or to the ground floor and put your oil into these receptacles. Anyway, that bill has died. And I think a lot of people are happy about that. Well, we've run out of time. And so I thank you very much for joining us today for this episode of Condo Insider. And please tune in next week, Thursday, for another episode of Condo Insider. And this is about condominium living, and it's for people who live and work in condominiums. Thank you and mahalo for joining us.